G'day everyone, and welcome to the second video in week 4 of our legal ethics course. This week we're looking at the paramount duty of every legal practitioner, our duty to the court. We're focusing on 3 aspects of the duty: independence, candour, and what are called undertakings. In the first video we looked at the duty to bring an independent mind to each case and to the presentation of each case. We are not the mere mouthpiece of our clients. In this second video, we look at the duty of candour. There's a very funny movie from 1997 starring Jim Carrey called Liar, Liar. The movie is about a lawyer who has basically gotten rich by his ability to lie to everyone from his son to the judges. And then suddenly, for one day, he finds himself unable to lie. And his world falls apart in amusing ways. The movie draws on the common public perception of lawyers as people who will say anything to win an argument, people who will lie convincingly for their client. Some clients whose understanding of lawyers comes from this public perception expect that lawyers will be ready to lie for them. In reality, nothing could be further from the truth. If you're going to tell lies, especially in a court environment, your career is going to last about 5 minutes. We have a duty of candour, a duty not to tell lies, but it's deeper than that. The duty of candour is a duty to tell the truth. Half-truths, white lies, things that are true but misleading, all of these breach the duty of candour. Let's start with the most obvious one. You must not mislead the court or allow the court to be misled. Rule 19.1 of the Australian Solicitors' Conduct Rules says a solicitor must not deceive or knowingly or recklessly mislead the court. You must never, under any circumstances, ever say anything in court or write anything to the court which is even slightly untrue. This has been emphasised so many times in so many courts that it's genuinely difficult to settle on a single authority to refer to in this video. But I'm going to quote from the judgment of Master of the Rolls Donaldson in the matter of Absey and Smith, who said, "The public interest requires that the courts shall be able to have absolute trust in the advocates who appear before them. The duty of the advocate is much more complex because it involves divided loyalties. He wishes to promote his client's interests, and it is his duty to do so by all legitimate means. But he also has an interest in the proper administration of justice to which his profession is dedicated, and he owes a duty to the court to assist in ensuring that this is achieved." Think about that. Absolute trust. The court must be able to have absolute trust in everything that you ever say to the court. It's a very, very high standard, and you must meet it. There's no wriggle room here. Does it begin to make sense why the court will not admit people to practice if they have a record of dishonesty? Now, it makes sense that if you're not allowed to mislead the court yourself, you're also not allowed to let other people mislead the court. Generally speaking, this occurs when a practitioner becomes aware that their client, or perhaps witnesses supporting their client, intend to give false evidence. All of this is covered by Solicitors' Conduct Rule 20.1. This rule is perhaps just a touch more complicated than the rule requiring solicitors to have personal candour. You see, as a legal practitioner, you're entitled to follow the instructions of your client. If your client is adamant that they woke up one morning and the sky was bright green, then what are you to do? I've certainly been in the position before where I had clients telling me stuff that I was pretty sure was just a bunch of nonsense. What are you supposed to do in that situation? Well, first up, you're not required to be too credulous. In other words, you're not required to simply accept things which are untrue because your client says that they're true. You're allowed to test the things that they're saying. You're allowed to reality check your client. You're allowed to gently tell them that in your view, a judge or a jury are unlikely to accept their evidence as being true. You're allowed to point out logical or evidential weaknesses. But at the end of it all, If the witness staunchly maintains their evidence, then it's not up to us to usurp the judge. In a case called Carvier Holdings and Werncog, Justice Santos said a legal advisor depends on the instructions given. Nonetheless, the legal advisor should remain alert to the importance of ensuring that he or she can fulfil the personal duty of candour that he or she owes to the court. If in doubt about the veracity of the instructions or their potential to mislead the court, the legal advisors should press the client until properly satisfied that such potential is removed, and in the meantime must decline to put submissions to the court while in doubt about their potential to mislead. The point may be reached where the lawyer ceases to act. It's a lot easier if the client tells you outright that they intend to give false evidence. In that situation, the best thing you can do is give them a gentle lecture about the importance of being honest before the court and the potential consequences of perjury. If that doesn't change their mind, then you tell them that you will not be a party to their perjury and you cease to act for them. You must not, at the end of the day, be a party to something that you know for sure is perjury. The next one's pretty obvious. Your duty of candour doesn't just include things that you say. You also can't submit before the court any document that you know to be false or misleading. This includes things like forgeries, but also affidavits that contain false evidence. In a case called Coe against the New South Wales Bar Association, a New South Wales barrister was struck off after he filed a false affidavit in which he misrepresented his income in his own family law proceedings. Again though, if your client brings forward a document, you're not really required to forensically examine it to assure yourself that it's the real thing. But if you know that a document is false, you can't submit it to a court. Now, of course, sometimes it might happen that you submit a document or make a statement entirely believing that it is accurate, but then something changes. You might, for instance, subsequently learn that the statement is false, or a statement may have been true at the time that it was made, but then something may change so that the statement was no longer true. Under those circumstances, there's obviously no misconduct in making the statement in the first place, but there would be misconduct if you allowed the court to continue on in the belief that certain circumstances were true if you knew that they were not. The key case here is a case called Vernon and Bosley No. 2, a case with more than a touch of the tragic about it. It involved a man whose world fell apart when his 2 children were killed in a car accident where their car went off the road and over the side of a bridge. He saw the unsuccessful attempts by emergency services to dive in and save them from the car. He claimed, unsurprisingly, damages for the mental shock arising from these quite awful circumstances. At the same time, however, it seems that his marriage fell apart and there was a contest over custody of the surviving children. He was therefore involved in 2 pieces of litigation at once. He obtained a report from the psychologist which showed that he was mentally very unwell as a result of his distress. The court in the nervous shock case proceeded on that basis. Later, however, he received another report from the same psychologist prepared for his family law case. That report was much more positive. If that report had been placed before the court for the nervous shock case, the damages would have been much less. His lawyers advised him that he did not have to disclose the second psychological report. Do you see the problem? The court found that even though the first psychological report was a proper report, properly placed before the court, the plaintiff was under an obligation to disclose the second report, which suggested that the contents of the earlier report were no longer true. From the perspective of day-to-day practice, the lesson here is pretty simple. Don't tell untruths. And if you find out that you have inadvertently misled the court or things have changed, then immediately take steps to correct the record. So, all of the things that we've talked about so far involve candour as to facts before the court. But there's also a duty of candour as to the law. This has three aspects. First, a practitioner before the court must assist the court to follow all of the proper procedures and must not knowingly allow the court to fall into procedural error that might make the case open to appeal. So if you're aware of some procedural defect, even if it assists your case, you have to let the judge know. A recent example was considered in the Queensland Court of Appeal in a matter called the Crown and Ferry. The accused in that case was charged with dangerous driving causing grievous bodily harm. After the incident, he participated in an interview with police. In that interview, he made what are known as inculpatory statements, so statements that tend to suggest guilt. He also made exculpatory statements, so statements that tend to suggest an absence of guilt. The prosecutor sought to tender an edited version of the interview, excluding the exculpatory statements because they were inadmissible hearsay. The effect, of course, would be to place before the jury all the stuff suggesting guilt and none of the stuff suggesting an absence of guilt. The judge went with it. On appeal, the Court of Appeal set the conviction aside, and President Sofronoff said, "It is the duty of both defence and prosecutor to make submissions of law only upon the strength of relevant authority that counsel has actually read and considered, and the significance of which he or she can explain comprehensively and accurately to a judge. It is part of every counsel's duty to assist the court in this way. It is also the duty of a prosecutor appearing in court to be familiar with basic principles of evidence, such as the elementary and long-established proposition that a prosecutor cannot censor a record of interview to exclude the parts that help the accused. So you can't make submissions to the judge on procedural matters that will lead the judge into error." The next one I've always thought really fascinating. You can't withhold from the court any binding authorities, not even authorities that go against you. So let's say there are two important cases relevant to a proposition that you're trying to put to the court. One of those cases seems to help you a lot. The other one seems to go against you. You cannot, under those circumstances, simply pretend that the second judgment doesn't exist. You cannot make submissions to the court as though your preferred judgment is the unchallenged authority. Instead, what you must do is make the submission that your case is the preferable authority and show why after discussing both. In a case called Rondell against Worsley, Lord Reid said, "Every counsel has a duty to his client, fearlessly to raise every issue, advance every argument, and ask every question, however distasteful, which he thinks will help his client's case. But as an officer of the court concerned in the administration of justice, he has an overriding duty to the court, to the standards of his profession, and to the public, which may and often does lead to a conflict with his client's wishes or with what the client thinks are his personal interests. Counsel must not mislead the court. He must not lend himself to casting aspersions on the other party or witnesses for which there is no sufficient basis in the information in his possession. He must not withhold authorities or documents which may tell against his clients, but which the law or the standards of his profession require him to produce." The final duty of candour occurs in a special type of matter called an ex parte matter. Ex parte is Latin for without the party. In most court matters, natural justice requires that if you're making an application against somebody, you have to serve the application on them and give them the opportunity to come and be heard on that application. We have an adversarial system of justice in which the fundamental expectation is that both sides will be standing in court to argue for their own interests. Sometimes, though, that's not possible or even desirable. Sometimes this is because an application must be filed very urgently. But even in urgent applications, the applicant is expected to do what they can to put the other side on notice. Some applications, though, by their very nature, would not work if the other side was on notice. For instance, an Anton Pillar order is almost like a civil version of a search warrant. It's only used when there is a realistic likelihood that the other party will destroy evidence. Now, it would defeat the purpose if that other party knew about the Anton Pillar application, wouldn't it? They'd have a big old evidence bonfire, probably toast marshmallows. If you're making an ex parte application, though, the court is only getting one side of the story. And so you have an obligation of candour requiring you to fairly put both sides of the argument. This requirement is 170 years old, having been established by Baron Rolfe in an 1850 case called Dalglish and Jarvie, where Dalglish had obtained an injunction restraining Jarvie from marketing printed calico which they claimed offended their copyright. However, they did not provide the court with all the facts. His lordship said, if the party applying for a special injunction abstains from stating facts which the court thinks are most material to enable it to form its judgment, he disentitles himself to that relief which he asks the court to grant. I think, therefore, that the injunction must fall to the ground. Nowadays, Rule 19.4 of the Australian Solicitors' Conduct Rules says effectively the same thing. So, that's the duty of candour. You cannot, you must not ever lie to the court about anything at all. You must not allow others to do so, and if your client is adamant that they intend to lie, you must withdraw. You must not tender a false document. You must correct the record if you find that the record is incorrect, and you must not allow the court to fall into error procedurally or by failing to put before the court relevant authorities, even those that go against you. Finally, in an ex parte application, you must fairly put both sides before the court in an attempt to ensure that justice is done, even though only one of the parties is present. In the third and final video this week, we're going to conclude our examination of duty to the court by looking at a special type of promise called an undertaking.